For those who are joining us as victims or witnessing the case, can you please keep your camera off until your case is called? You still can observe the session, just keep your camera on so the judge know who to address at the time. Thank you. Hi, Judge. Can't hear you.
There we go. Good afternoon.
Did you get my message in the chat?
Oh, I was looking at my computer. Hold on. Oh, yes.
Okay. Even though it printed out wrong on the count, I just didn't want nobody to go crazy.
No, right? It sounds
Yeah.
a long time away.
And your reset date is it's gonna be February the 26th at 9 o'clock.
Uh-huh.
That's on a Thursday. Reset dates for the SAP is February the 26th.
26. Got it. All right, if we're ready to start, I was gonna say, where's the state? Hello, ASG Pope, how are you?
Good afternoon. I'm well. Happy Valentine's Day, everyone.
Yes, happy Hearts Day. We don't get you on a Saturday too much, so I know.
Every once in a while.
Right, right. All right. Where are you by yourself, Mr. Morrell?
No, Attorney Green will be joining us. She's in our office. They're having a little internet connection. So, but courtroom 2 knows who my clients are.
Okay, good. Okay, great. All right. Everyone, we're going to start our Fulton County State Court Expedited Accusations calendar. And this is a calendar for cases which have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. As you've already heard, the SAP reset date is 2/26/26, which is Thursday at 9 a.m. on the 26th. I want to also remind everyone on this calendar that this whole entire proceeding is being recorded as well as live streamed on YouTube. So govern yourselves accordingly. I want to also remind the inmates here that you have certain constitutional rights. The first being that you have a right to counsel. At this juncture in your case, you should know who your attorneys are by now and have spoken to them. If anyone needs to speak to their clients, then let us know. We'll put you in a breakout. Also, you have the right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be held against you. The state is here, they're listening. So again, follow the lead of your attorney. All right, who do we have first, deputies?
Position 16, Mr. Price.
Okay. This is 26 CR 001013L. Darius Price, charge of 1 count of battery, family violence, pretrial.
Yeah, 32. Got an open simple battery, 25 CR 007 444L. Simple battery DV 25 CR 003 188L. Got an open trespass, possession of marijuana, possession of cocaine out of DeKalb County. On probation in the cab, 2 counts of ag assault, 1 count of terrorist threat. 2019 fade to appear, 2013 battery DV conviction. This was level 3. That's all.
Okay. State.
Good afternoon, Your Honor. The 2 cases that were just identified by pretrial are simple battery family violence against the same victim as this case. The state is filing an emergency motion to revoke the defendant's bond. as he was to have no contact with this victim in each of those cases. And this present case, which has been elevated to a battery of family violence, he has had contact with the same victim again. Additionally, the state did ask this morning that this case be sent up to the DA's office. We had not heard back by the time that the accusations were due, so it was filed as a battery, but it would be his subsequent or a second or subsequent battery family violence conviction if convicted. Very quickly, the brief facts: on February 12, 2026, officers responded to 767 Mercer Street, which is an address that he was asked to stay away from in both of the prior simple battery family violences. The allegation is that the defendant and Miss Kelly were in a dispute. He wanted her to do something that she didn't want to do, go to the doctor's office with him. He poked her in the eye, busting a blood vessel. EMS did respond and notated that she did have a busted blood vessel in her eye. The state would ask, I mean, obviously he's entitled to a bond on a misdemeanor, but we would ask for a $5,000 cash bond. No further contact again with Kelly Price. Stay away again from 767 Mercer Street Southeast. I was trying to see if those motions to revoke bond on the underlying cases had been filed. I don't know if that's something that you can address, but we are asking that his bond be revoked and he remain in a no bond status on those two other misdemeanors against the same victim.
All right, pretrial, are those pretrial bonds or?
They're both surety bonds. He had a $4,000 surety bond and a $2,000 surety bond.
Oh, okay. Is this Miss McLeod or Green?
Yes, Your Honor. Good afternoon.
Good afternoon.
Yes. My client is not in a position to pay a cash bond. I discussed with him what happened, and he tells me that he's not been around the alleged victim since he got out of jail the last time. He denies that he was in contact with her on this particular date, Your Honor. My client is entitled to bond, as the state says, and a reasonable bond as well. So I am going to ask the court to set as low a bond as possible and let it be a surety bond, because I understand that the court is not going to give him a signature bond. Nothing further, Your Honor.
All right. Normally, when there's a second or third case with the same victim and we're surrendering bonds, I do cash bonds. So I don't know what we're going to have to do to stop having cases, I guess, but I'm going to order the $5,000 cash bond. And again, stay away from 767 Mercer Street. No further contact with the victim, Kelly Price. And no drugs, alcohol, weapons, or guns while on bond.
Your Honor, I think she has a different name, the victim.
Oh, let's see, what is the?
It's Kelly, Bianca Kelly, I believe is her name.
I may have said the wrong name.
Okay.
It's his last name is Price. It is, thank you. It is Bianca Kelly.
Okay, Bianca Kelly. B or D?
Yes, Your Honor. B as in boy.
B as in boy. Okay.
Yes.
All right. Bianca Kelly. No further contact with her. To stay 200 yards away. And all the other conditions that will be on that bond.
Can y'all clarify the address? Because that's what he has as his residence on the Odyssey.
Oh.
The stay away address is the same address on Odyssey. Is that his permanent address?
He shouldn't be at that address in accordance with both of his other prior bonds. So I'm not real sure why that would be it should not be the address.
Well, if it is, he needs to go live somewhere else. So stay away from that address if that's the incident address.
It is, and there's a bond condition.
one-time police officer escort on his last bond to go back there to get his belongings. So
you say you had one on the last one?
That is correct, Your Honor. He had a one-time police officer escort back to that location to get his belongings. So my understanding is that he has already moved from that location.
All right. Well, stay away from there. The biggest thing is to stay away from this victim. have no further contact with her of any sort. All right, 5,000 cash. That'll be it.
Thank you, Your Honor.
Thank you.
That concludes my business before the court today. May I be excused?
Yes, you may.
Happy Valentine's Day.
Same to you.
Thank you.
Position 4, Ms. Fish.
This is 26 CR 001 009Y Starler Fish, charged with 1 count of simple assault family violence and a 2nd count of simple battery family violence. Pretrial.
So 4th arrest. Last was 2006, suspended license. This is level 1. That's it.
Okay. State.
Yes, Your Honor. On February the 13th of 2026, the officers went to 174 Howard Street Northwest, where Miss Fish and Miss Cook had been involved in a altercation. The victim's name is Kaylee Cook, first name spelled Kaylee, Cook, Cooke. During this time, it appears that they got into a disagreement in which Miss Fish took the wig off of Miss Cook's head and hit her in the face with it. Thereafter, she kicked her in the stomach and the leg, and she had to be pulled away by her son, Mr. Fish. All the parties were living in the same household. Our bond recommendation in this particular case is for a $5,000 surety bond, $2,500 on each count, that she have no further contact with Miss Cook, and that she stay away from the residence at 174 Howard Street Southwest. No alcohol, drugs, or weapons while out on bond. Thank you, Judge.
All right.
Your Honor, this is going to be my client, Miss.
Okay.
To start off, Your Honor, Miss Fish is actually the leaseholder for 174 Howard Street, as indicated. Miss Cook is the son. It's Miss Fish's son, mother of her children. She has no rights to that property. That is actually Miss Fish property, where she lives with her 8 children, including the son is able to stay there, Your Honor. Now she's 50 years old, Your Honor. She has not only has her children there, but she also has her grandchildren there as well. And then it's a duplex. So her other son lives on the bottom, at the bottom unit, and she sometimes watches their children at that household, Your Honor. Now, as far as my client, she does have some, she's graduated college. She has her associates, Your Honor. She doesn't present with any mental health, any severe health diagnosis, or any drug abuse, Your Honor. And she is working as a case manager, Your Honor. But what I would be asking is for, on the assault, I would be asking for a SOB, and I would ask for a bond no higher than a 1,000 on a simple battery. I would ask that you do not place a stay away from her home, Your Honor. She has no, if you put a stay away, she has no place to live in, as well as you'll be displacing the family, as well as the grandchildren which she provide for.
All right. Do we have, by chance, an address for Miss Cook at all?
The 174 Howard Street is her address. You talking about Miss
For
Cook?
the victim. I'm sorry. Yeah. Do we know?
That's the only address that I have at this time, is that address where she was living at the time of the incident.
I do understand the situation, especially with the number of kids involved and things of that nature. And the only thing I can do, Mr. Morrell, is say that she can go back and they can sweep that location. And if, the victim is not there, she can stay there.
Your Honor, would you be willing to do, since she doesn't have any criminal history, to do a no further violent contact with Miss Cook because think about this is a 50-year-old woman with 8 children, and of those 8 children, she has a child that has autistic needs, a 17-year-old, a 16-year-old, and a younger child at 7, Your Honor. And just by displacing her, that's also displacing the children in which she provides for.
Mm-hmm. Has the state spoken to the victim, Ms. Cook, at all?
No, Your Honor, which is
No.
why we have to make that recommendation.
Well, first, what I'll do, I will give her the $5,000 signature bond through pretrial,
Mm-hmm.
and that's $2,500 on each. No drugs, alcohol, weapons, or guns while on bond. I wish we could hear from the victim, or even I don't know, Miss Fish's son regarding this. I
I
guess
mean, she doesn't have a violent history or anything. That's why I said let's give her at least the benefit of the doubt.
All right, we'll try it. No further violent contact with Miss Cook. And since it's through pretrial, I'll ask her to take 3 anger awareness courses.
Thank you, Your Honor. I appreciate it.
All right.
What level was this, Judge?
Oh, I'm sorry, level 1.
Position 10, Ms. James.
I'm done.
This is 26 CR 0010114A. Kia James, charged with 1 count of endangering a child by driving under the influence of alcohol, DUI, and following too closely. Retrial.
8, 2018 and 19 suspended license conviction. 2017 suspended license NOLO. 2016 DUI conviction. I got another 2016 DUI arrest with no disposition. This is level 1. That's it.
All right. State.
Yes. In this particular case, it appears that there was an accident involved in this case, in which on February 13th of 2026, the officers were dispatched to the accident at Cascade Palmetto Highway and Hall Road in South Fulton. Once there and spoke with the parties, it appeared from the statement that the victim, we will call Mr. Evans, indicated that he saw a vehicle that was stopped in the middle of the roadway. He advised he went around the vehicle and stopped at the intersection and traffic light. And all of a sudden, the driver, Miss Thomas James, hit him in the back of the car. As a result, the officers, when they arrived there, the witness indicated that they saw her stumbling out of the car. The officer indicated she was stumbling out of the car, smelled alcohol, did conduct some field sobriety tests at the time that indicated that she was, by all accounts, that she had validated some of the indicators of impairment. He read implied consent to her. She refused further testing at that time. So our recommendation for bond is we were making a recommendation for $5,000 as to the child endangering, 5,000 as to the DUI, and 1,000 as to the following too close. It would be a 11,000 surety bond, no alcohol, drugs, or weapons. While out on bond, she cannot drive without a license. I thought I saw something that her license may be suspended on her driver's history, but that was not one of the charges. Thank you.
All right. Is it PD Green?
No,
Or-
it's going to be myself, Your Honor.
Okay. Go ahead.
Miss Kaya Green, she's 46 years old, Your Honor. She's also a lifelong resident and has a residence out of Fulton County. As indicated by pretrial, she doesn't have any FTA, so she doesn't pose a significant risk of fleeing from our jurisdiction. In her residence, she does provide for two children, a 10-year-old and a 15-year-old, as well as she does have some cousins in which she also provides for. She does have 3 years of college. She was studying broadcasting communications, and as well as she is currently working at a restaurant in Midtown, Your Honor. She doesn't present with any mental health, Your Honor, but she is battling breast cancer, Your Honor. With that being said, I don't believe that the DUI charges is restricted from a signature bond, Your Honor. I would ask that she is provided a signature bond. Oftentimes, when we're in Judge Taylor's courtroom, that is my courtroom, we see the people who have DUIs. They usually have signature bonds coming over from City of Atlanta or the other precincts.
Mm-hmm.
And that's including with the endangering a child charge.
Well, and she's got some history here, and obviously DUI histories. Are we looking at solving this issue or working on this issue that she may have, even with the cancer? I will give her a $9,000 signature bond through pretrial.
Mm-hmm.
On the first charge, it will be $4,000. Second charge DUI, $4,000, and $1,000 on the following two close, for a total of $9,000. Level 1, I'm going to require her to go to 3 AA classes a week at least, if not more. No driving without a license. I almost want to say don't drive, period, but I guess that's all I can do at this moment. What are we going to say?
In consideration of her previous two DUIs, I would ask that it be at least at a level 2 versus the level 1.
Well, if anything, I may do random screens or things of that nature. Reporting to pretrial may or may not get the solution that I want, which is her to get some help with drinking, obviously. Pretrial, who does the random screens? A random screening?
Some company, I'm not sure. I never asked, to
Is
be
that
honest.
something you all set up?
I think they do. It's
Yeah.
supervision, so that's
Mm-hmm.
their expertise.
I know. What were you gonna say, Mr. Morrell?
When it comes to the random screens, what I fear is that oftentimes when we take the cases with random screens on probation, the client has to bear the cost every time that they have to go screen, etc., depending on how often they have to screen. I believe that if it's any kind of way that the county can be able to pay for the screenings, the getting the testing done, that would be able to most alleviate the hardship on Mrs. James, because we don't know how long it's going to take to resolve her case. That can be a long, extensive period of time of having to continue to pay on something where funds are limited.
The other side to that is the ADET with recommendations of treatment to have her evaluated, and that cost as well. I just don't want her to kill somebody, herself or a child that she's riding with, as DUIs can go totally left quickly, and especially when we're talking about this is at least her third one.
No, I understand. I just didn't know if the county can absorb the cost. Kind of like, I don't know if it's like an ankle monitor where the county can pay for the ankle monitor. Not
Does
recommending an
anybody
ankle
know?
monitor, but just saying in general.
Right. Does anyone know? Because I hate to order things that I don't know about, or then they say, well, you can't do that, and judge ordered such and such, and then they get mad. The judge is telling us to do something we cannot do.
And if
And
we would oppose the county paying for it, if this were her first DUI, I would understand that argument. But on someone's third arrest for DUI, I think you've already given her quite a bit of leniency in giving her a signature bond on a third potential arrest for DUI. So the state would oppose asking the county to pay for it and ask Ms. James to pay for it, and that she's in the best position not to be in this situation. Furthermore, there's an accident involved and a child in the car. So this is a very serious case by the state's perspective. And we would ask, we were asking for $11,000 surety bond. So we certainly would not be consenting to, or would ask that the court not ask the county to pay for any testing of drugs or alcohol. I think at a minimum with a signature bond, that's the least that the court should be doing.
Mm-hmm.
And Your Honor, I guess the issue then becomes what happens if, and we see this all the time, is that we have an indigent person, and then when they run out of funds, because they still have to be able to live. And then if they don't have any funds to be able to pay for the random screening, now we're looking at violation. Now the state jumps up and wants their bond to be revoked. And we are in this rigmarole that could have been prevented when I've already presented that she works at a restaurant and that she may not be able to afford to be able to pay the random screens. That's why I raised it. Etc.
State's concern is still the public safety. And because DUI is something that is against public safety and there's an accident, I understand the argument, but the state is still very concerned with this being a third DUI, arrest at a minimum, certainly a second DUI conviction. We would still ask, obviously, for the surety bond, but we've moved on from that. At a minimum, the drug screens and alcohol screens.
I'm going to take it there. Let's see what happens. I guess you could always apply for a bond modification if you find out that she can't afford it before she is in violation. I've got her going to the AA classes. And with the random screens, I guess it would be if she's at a, I don't know if I make her a level 2 and then she gets screened at one of those. Because I think level 2 is two a month. And then she comes in. Do you know pretrial with the screening?
She report twice a month.
Right. So we'll put her on
I
a level.
don't know how the screenings go. You just have to order it, and I don't know how it goes.
Right. I'm gonna put her on a level 2 and at least one screen a month. And the AA classes, maybe we'll get her some help. And no driving. No drugs, alcohol, weapons, or guns while on bond. And let's see what we can do or see what happens. And if we find out something, you all find out something about the screens not being available or something she can't do, then you can file a modification. But I want to put them in there for right now. You know anything, Ms. Lewis?
No, I was just gonna ask you how many, you said 10, 3 AA meetings. Is that weekly, monthly?
Weekly.
Okay.
And Judge Mincy, are we capping the one screen per month? Is it like for 6 months? Or I've seen that where Judge Taylor has done that on some of our pleas. But I just didn't know if you have it for indefinitely until it gets resolved, or for 6 months, 9 months.
What's your opinion on that, State?
We would ask that you just make it, if they want to ask for a modification
Condition of the bond.
in 10 years, this
Yeah.
case will likely be going to Judge Taylor. So hopefully Mr. Morrell will be able to represent this defendant in Judge Taylor's courtroom. But I am going to ask that a case cognate order, transfer order be applied on this case. Let me see who it's assigned to now.
Okay.
So that's something he certainly can bring forward in front of Judge Taylor or Judge Edline.
Right.
Right.
Okay.
I guess the defense will ask that you put some cap on it. It could be 6 months, 9 months, etc., because it sometimes takes a while.
Right. So a modification of bond can be filed at any point. We would just ask that while she's on this bond, that be the condition. And if they find that she's doing extremely well, then certainly ask whatever judge it's assigned to for a modification.
It's assigned to Judge Roth at this time.
I see Roth. Okay.
Okay, Roth.
I may go ahead and file the case cognate order so that it can be transferred to DUI court, since it would be one that would have to go to DUI court anyways.
Mm-hmm.
And you have to remember, Judge, that the pretrial services supervision on these orders are 6 months. So if you want duration of additional time, you gotta let me know.
Okay. Well, let's just do it at the 6 months. By then it'll be in someone's courtroom to address it or do a modification order. I'll just put on there 6 months for now.
Thank you.
And go from there. Hopefully she'll be in the AA classes that'll help a little bit as well.
Thank
So
you.
we'll do 6 months of the random screening once a month and then see where we go from there. All right. Anything else?
Nothing further from the defense.
Okay. Good afternoon.
Oh, I represent all the ladies at ACDC.
Oh, okay.
This is position number 3, Miss Evans.
Okay.
Hello.
This is 26 CR 0010003E. Brandy Evans, charged with 1 count of possession and use of drug-related objects.
9. She got an open theft by taking. 19 SC 169926. It's in judicial hold. 2023 fade to appear. Jail's a recommendation. That's it.
Your Honor, this incident occurred January the 17th of 2026. Officers were patrolling the area of West Broad Street and Cole Street in Fairburn, Georgia, when a car made an improper lane change, and it appeared that the driver of the vehicle was Hamilton Cook, who had an outstanding warrant for failure to appear. They conducted a consent to search, including items in the car. They located, as to Mr. Cook, a crack pipe and a bag with cocaine in it. And as to Miss Evans, her bag had a crack pipe in it. But she didn't have any warrants out. They were taken for medical clearance and left at the hospital, and the warrants were taken out. The bond recommendation in this case is a surety bond of $1,000 already been set by the magistrate. We would ask that it remain the same. No alcohol, drugs, or weapons. I would ask that she see a social worker for BH before she leaves, and are concerned for her based on the allegation, whether or not she has any alcohol, drugs issues that the social worker can help her with.
Ready?
Right.
For, all right.
Yes.
Before us is Judge. No, sorry. I was about to say Judge Brandy Evans. Before us is Miss Brandy Evans. She's 50 years old, Your Honor. She is a lifelong resident. I know you're concerned that she had 1 FTA, Your Honor, but of 9 cycles, Your Honor, I think that may have just been, maybe had an accident, etc. She does have a valid address out of Palmetto, Georgia. She does live with her parents. I did speak with Miss Royce Evans, who is her mother, who indicated that she would be able to come back to said home. She does have 2 adult children, and she's also graduated high school. As far as health concerns, she did want me to share with the court that she does have blood clots, and that's due to stroke, so she is under medical care, Your Honor. I would be asking for a signature bond in this particular case, Your Honor. My understanding of this particular case is that the driver, Mr. Cook, he had a warrant, as the state indicated. He wasn't arrested, but then he has a consent. But then I spoke with Ms. Evans, and she indicated that she had this car belonged to Ms. Evans. She also indicated that she was kind of objecting to the search, Your Honor. And I think that that goes to a question of where we will handle that later on about in the Fourth Amendment if they had the true consent to be able to search the vehicle. Because although Mr. Cook had the apparent authority, car is registered to Miss Brandy Evans. She had the actual authority, Your Honor, and so I would be asking for a signature bond because this may be a case in which this evidence will be suppressed because it was found in her pocketbook due to a search that we believe is unlawful.
And I will just correct she has 2 FTAs in the last I guess in the last 10 years, because she has one from 2018 as well as one from 2023.
Okay. All right, so she has a preset bond at 1,000 surety. I'm gonna leave that bond there at the 1,000 surety bond. No drugs, alcohol, weapons, or guns while on bond. And I think that's it for the moment. What do we have next?
Judge, can you repeat the bond for her?
1,000 surety.
Next, we have position number 12, Miss Manning.
Is that Chelsea, man?
Yes.
Okay, we have a consent bond in that, Your Honor. But
Oh,
Ms. Chelsea,
okay.
have a seat for us.
Oh, okay.
I'll let you call the case and make the
I'll
announcement.
call it 26 CR 000946E. Chelsea Mann's charged with 1 count of cruelty to children in the 1st degree.
No, I had her.
Is this
No,
in the record.
Judge. This is
Oh.
a transfer from Superior Court. That was her original charge. So that the charge that they transferred down was reckless conduct.
Judge, that's the one I was telling you about, position number 12 in the chat. That's what I was telling you about. The charge is wrong on the calendar, but it's correct in the system. And Odyssey part, but it's just.
I don't have a chat message from you on that.
You don't?
Only have 2. One from you and one from Mr. Jordan.
No, I did send you one, a private one.
Did you press send?
Yes, ma'am.
All right. Well, it's a reckless conduct and you have the consent bond?
Yes, Your Honor. And if you could, or Ms. Mann, we basically consented to you having a signature bond, so you won't have to pay anything to get out. Ms. Battle, do you have the amount on it? I
It's
forgot
a
what.
$2,000 signature bond,
All
level
right.
on.
Oh,
She's
it's the signature bond through pretrial or jail?
through pretrial services.
Okay.
She's to see a social worker before she leaves the facility, comply with the DFAC safety plan, no further violations of the law, no alcohol, drugs, or weapons while out on bond.
So
All
that
right.
means that, Ms. Mann, if you get arrested again, then you have to put up $2,000 for this bond, just so you're clear, but you're not going to pay a bond today.
Okay.
Thank you.
Next is position number 14.
Okay.
This is 26 CR 001017A, Natalie Otinio, charge of 1 count of simple battery family violence.
3rd. Got an open DUI to Texas. No. XRDWI conviction, actually. And this was level 2. That's it.
All right, state.
Yes, Your Honor. In this particular case, it was January 30th of 2026. It appeared that there was a report of a missing child at 1355 Grand Creek Drive and Roswell. It appeared that the mother of Miss Otinio is Gertrude Mumachi, Mumachi, and Miss Otinio had been drinking at the residence that evening. The child had been with her in the vehicle. At some point in time, the child was taken into the home. Miss Otinio started knocking on the door, indicating that indicated that she thought that the child was missing. They were calling the police, and it turns out that the child was asleep in the residence. Miss Otinio, during the course of this, was pushing and shoving, and she pushed Miss Mumachi in front of the officers, and she was arrested as a result of it. our bond recommendation for the simple battery. I think Ms. Mamachi was on the line earlier. But my original bond recommendation is for a $3,500 signature bond through pretrial services. I wanted to do that at a level 2. I would like for her to complete and start at least the process for ADT and no further contact with Gertrude Lumachi and stay away from the 1355 Grand Circle, CRIQUE Drive. No alcohol, drugs, or weapons while out on bond.
All right. Is the victim on the line?
Yes, Your Honor. She's under Gertrude. She's there.
All right. Ms. Mamachi, do you wish to briefly address the court today? This is not a trial.
You're muted, Ms.
Can't
Gertrude.
hear you.
Click on your screen and click on the microphone to unmute yourself.
Still
Oh.
muted. Oh, she might have pressed the wrong thing.
She pressed the video camera, but you got to click on the actual microphone. It's at the bottom to your left corner usually.
She's still there, Miss Lewis?
Yeah, she's there.
I can't see.
Yeah.
All right, we got to keep moving.
Okay. Your Honor, I did speak with Miss Gertrude. She actually she's not opposed to her daughter being able to live back with her. And as well as she actually said she didn't want the case to go forward when I spoke with her, Your Honor. I understand that at this point it's in the state's hand. But she was not opposed to her being released. And she did ask for I know she was going to say she's okay with the no further violent contact. Your Honor, other than that, we have no other contesting of what ASG Evans Battles recommended with the signature bond level 2 ADET. We just asking that it says no further violent contact and to not have the stay away because her mother is okay with her living there. I spoke with her before the hearing, Your Honor.
Okay. All right, so we'll do the $3,500 signature bond through pretrial level 2. And no further violent contact with the victim, Gertrude Manicho, I believe. No drugs, alcohol, weapons, or guns while on bond. And an ADET, follow any treatment recommendations. And I think that'll be it for now.
Thank you.
Position 7, Mr. Harris.
Okay.
I missed the name.
Position 7, Mr. Harris.
Oh, gotcha.
This is 26 CR 001016J, Shamar Harris, charged with 1 count of battery and 2nd count of simple battery.
Third, got an open firearm case in marijuana out of DeKalb County, 2025. 2023 battery dismissed. This was level 2. That's it.
Yes, Your Honor. In this particular case, the incident occurred on January the 26th of 2021, I'm sorry, on January 21st of 2026 at the home of Miss Morse's mother, Miss Brianna Victor's mother, Samantha Victor, who actually was the one who called the police, provided a video surveillance of the incident captured there in which Mr. Harris appeared to be, while they were sitting in the car in her yard, he started hitting her while she was in the car. He got out of the car. He was screaming and cussing and calling her names, telling her to get out of the car. He went around the vehicle and pulled her out of the car. And you can hear her screaming in the video for him to get off of her as he began. At one point in time, you could see that he had her by the hair, she had him by the hair, and she appeared to be fighting extensively through that process. At some point in time, he started to strike her in the face that you could see in the video. She's still saying, "Get off of me," and screaming. Then he starts saying, "Get off of him." He grabs her by the leg and drags her across the lawn. And in the final part of the video, you can see him landing blows to her face. And so as a result of that, she had black and blue bruises on her face. Her mother was able to see that as they work at the same location. And Miss Brianna Victor, who's the actual victim in the case, would not allow for photographs to be taken, but they did have the video there. There's also another witness as well to this incident. In looking at his prior history, which that his prior battery was a diverted case, but that pending open firearms case is concerned for us right now, and that is a 2025 case. So we are asking for a surety bond. We are asking for a surety bond in the amount of $5,000 for the battery and $2,000 for the simple battery. And so that would be a $7,000 surety bond, that they have no further contact, that he stay away from the location at the 5011 Estonian Drive, as well as the home of the victim, which I don't have that address. I'm not sure if she's going to be on the line. I see.
Who's on the line?
I think she froze.
She did freeze. And the victim is on the line if she wants to speak.
All right, Miss Manucci, we've already finished your daughter's case. So she can contact her attorney.
I'll give you a call, Miss Gertrude, when we finish.
Thank you. All right. And who is this, Miss Vickers?
Miss Victor, yes, that is the alleged victim in his case. Brianna Victor.
Oh, Victor. Okay.
Mhm.
Where is she?
Well, it says her name, but I saw her earlier, but she had a video. No, she turned her video off. Oh, there she is.
I'm here.
Miss Victor, you can't be walking around and doing things. You have to be stationary and still.
Okay.
Do you wish to address the court briefly today?
Yes.
All right. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth, nothing but the truth, under the penalty of perjury?
Yes.
All right. Are you in a store or something?
I'm at work, but I'm about to take a seat.
Oh, you're at work.
Yes.
So to make sure you were slightly in a confidential area, but it's up to you. Okay.
I have my headphones in, but you can continue.
Okay. All right. I have two questions for you. Are you in fear of Shamar Harris?
No,
Do you want to have any further contact with Mr. Harris?
I do wish to have contact with him.
Okay. Are you all residing together?
What do you mean by residing?
Do you live together?
No, we do not.
Okay. Do you have any children together?
No.
Okay. All right. I don't have any further questions. Anyone else?
No.
Nope. All right. Thank you so much for getting on. You can mute yourself and listen to the ruling.
All right. And Your Honor, so before us is Mr. Shamar Harris. He's 20 years old. He also is a lifelong resident As indicated, even with 3 cycles, he doesn't have any kind of FTAs, Your Honor, and which shows that he's not a significant risk of fleeing from our jurisdiction, Your Honor. And he lives out of Douglas County. He does live with his mother. He's currently in school. He's graduated high school. He's currently in school in Barber College, Your Honor. So he works a little bit on the side, but he just kind of cuts hairs on the side. But mainly his focus is getting through school, Your Honor. As far as when I had a conversation with Miss Brianna Victor, she also indicated that she didn't want the case to go forward. And she also indicated that she struck him first. And so what you see in the warrant is what happens on the video. But this altercation happened before the car even got to the house where Mr. Harris was driving and where she began to struck him. We do believe that Mr. Harris will have, based off of her conversation, a very valid immunity motion when he gets to his trial courtroom, Your Honor. And so I would be asking for the bond to be set at it's a battery charge, so it can't go through signature bond. I would ask for a bond to be set at a $1,000 bond, 500 on each, since the battery is restricted for a signature bond, and so that he'll be able to pay his bond and be able to get out of custody, Your Honor.
I'm going to order a and he has no preset bond, right?
Not to my knowledge, but I could double check for you on Odyssey.
Okay.
I have it pulled up. Choo-pa-choo.
No, he doesn't have a bond on this.
Okay. All right. I'm going to order a $3,000 surety bond, 1,500 on each. And with that 3,000 surety, I'm going to order him to have no further violent contact with the victim, Samantha Vicker. No drugs, alcohol, weapons, or guns while on bond. And I guess that's it.
Judge, the victim's name is Brianna Victor.
Oh,
Her mother
sorry.
is
The
Samantha.
mother's, okay, Brianna.
But he needs to stay away from that address, the 5011 Estonian Drive. That is the mother's address, I believe.
All right, and stay away from the incident location. And that should be it. Did I say no drugs, alcohol, weapons, or guns while on bond?
Yes,
Okay.
Your Honor.
All right. And I don't know, did Miss Gertrude freeze or did she?
No, she's still there because I can see her blinking.
Okay.
Or at least I
And
think
Miss
she's still there.
Gertrude, we have finished your case. You're free to go.
Or maybe she did freeze. I'm not
Maybe
sure.
she did freeze.
Yeah, but I'll give her a phone call. I have her number.
Okay. You can put her out, Miss Lewis, if you don't mind.
Mr. Jordan is hosting today, but I can assist.
Oh, Mr. Jordan, I'm sorry.
Oh, she's gone. Oh, okay.
Okay, there we go. Maybe she heard us now. All right, who do we have next, deputies?
Position 11, Ms. Majid.
This is 26 CR 001-007J. Rashad Majid, charged of 1 count of disorderly conduct.
This 9th, 2023 abandonment of dependent child, 2017 DWR, level 2. That's it.
State.
Sorry.
Mhm.
The state is requesting let me get back to my sheet. Okay. $1,000 signature bond through pretrial. I think he said level 2. I'll agree with the level 2. Random drug and alcohol screens. No further violent contact with Gordon Daniel.
Okay.
Your Honor, of course, we are not opposed to the signature bond.
All right, so it's a $1,000 signature bond through pretrial, level 2. I'm going to order 3 anger awareness courses through pretrial and no further violent contact with Garden Daniel. No drugs, alcohol, weapons, or guns while on bond. And that's all I order at this time.
What position was this? I'm sorry.
11, Majid.
Can you give me that amount one more time? I'm so sorry.
A $1,000 signature bond through pretrial, level 2. 3
you.
anger awareness courses through pretrial.
Thank you.
Position 18, Mr. Sparks.
This is 26 CR 001005E, Louis Sparks, charged with 1 count of violating a family violence protective order.
27. Got to open obstruction out of state court. It's 25 CR 006043E. Unlawful squatting. 25 CR 006042E. You got to open ag assault, criminal damage to property, simple assault, obstruction, cruelty to children. It's 25 SC 005834. Got to open theft by conversion. 22 SC 182232. Another forgery in the first degree, obstruction, and unlawful squatting. This is level 3. That's it.
Your Honor, there's a $28,000 surety bond already attached to this case. The state would ask that it just remain. The allegations are that he violated the bond conditions of the aggravated assault, criminal damage to property, and all the other charges, and that he was supposed to have no further contact with the victims in those cases, and he was in fact living with the victims, and that is the basis of this new charge.
And you said it's a 28,000?
They have a $28,000. The judge signed a $28,000 surety bond.
All right. Ms. Green?
Yes, Your Honor. Your Honor, of course, we would ask for a reduction, Your Honor, in this that, yes, there is the open felony case, but Your Honor, he was not living with her. He does live in a separate address in Union City. There was a family emergency and he did need to care for the children. They do have children together, Your Honor. And Your Honor, he did take care of the children, who is currently with his elderly mother, who he also takes care of, Your Honor. So we would please ask for you to reduce this bond. He does have 7 children. Again, as I stated, he lives at a separate address in Union City. He takes care of his mother, and because of the family emergency, I believe she is out of town. I believe Miami, but I cannot confirm that, Your Honor. But she had an emergency. He agreed to take care of the children, and that is what the contact was based off of, Your Honor. And Your Honor, he's lived at that separate address while this case was pending, Your Honor. So we would ask for you to consider reducing the bond.
And if I said, let me correct to say that the bond order says he was not to go within 200 feet of the victim that is identified, as well as I think 7 other victims. So he was not supposed to have any contact at all with those victims.
All right, I'm going to leave the bond as it is at the 28,000. It's got all these open cases and needs to stay away from these victims. I don't know how many times we can say it. Stay away from all of them, as the previous bond order stated. No drugs, alcohol, weapons, or guns while on bond.
Judge,
Yes.
he wishes to speak.
I don't know if his attorney's going to want him to. So you have a question about the bond?
I do, Your Honor, and I also want to state that I was in court when the children was dropped off, and I stated that in the courtroom that they were being dropped off. She was on her way to Miami while I was in front of the judge, Your Honor. I didn't have contact with her. The children and her was contacted with my mother while I was in court on Thursday. And I asked the judge on that day to dismiss the case because she wouldn't be here during the following week due to a funeral. And my trial date is on Tuesday the 17th. And the prosecutor, he sent someone to my house to look for Amy. They searched the house. Amy wasn't there. Only my children were there, and I'm only keeping them for emergency purposes, right? But I was not there when she left the children. I was in,
And Your Honor, indicating as far as the 7 children.
and we do have 7.
And that's why I was indicating as far as the emergency.
I'm an active father, Your
That
Honor.
is what the warrant was based off of.
And my mom, she had 2 what that is, 2 strokes and a heart attack. So she's 66 years old right now. I'm currently caring for her. But right now she's at home caring for my children. And she's not really in a position to really take care of them without me being around.
So the factual allegations are gonna have to be sorted out in court. It's not for me to do at this point. But with the, 1, 2, 3, 4, 5 open cases here in this court?
In this court, Your Honor?
Well, we've got the SCs and the CRs, I guess 5 open cases.
Are they not the same? I don't recall these 5 open cases, Your Honor. This one case, I think this.
No, we're not gonna go into that. But is that right, State? There's 5?
This case is predicated off of the open felony that is in Fulton County. Let me pull his history.
I know they're not the same cases. They have different. I thought they all had different numbers.
Well, the aggravated assault and all of those charges, it was a ag assault, criminal damage to property, and the 2nd degree simple assault. All of those are cruelty to children. All of those are one case. But let me just pull this history very quick.
Okay, so then that is 1. Okay. And that could be correct, sir.
I didn't hear you, ma'am. Judge.
I said that could be correct. I think 3 or 4 are under the 125 SC number. And then I've got the open obstruction and the 25 CR number.
And I think he does have 5 open cases in Fulton County.
I think they were September of 30th of last year. It was an obstruction charge and something like that. Unlawful squatting. It was a warrant.
Mr. Sparks, remember our earlier conversation?
Who's talking to me?
This is Annette Green talking to you, Mr. Sparks. I'm just saying to you, remember our earlier conversation? I did indicate that you will have another court date, okay?
I'm just trying to get bonded so I get my mom and my family. That's all.
I do understand and the court understands.
Right. And with that and the other cases, I'm definitely not going to give you a signature bond. So it'll be a surety bond. And right now it's 28,000. And I just don't have enough information to see whether to lower it or not at this point. And you'll come up on the next calendar for review. And then it can be looked at that time. So I'm going to go with what is already there, which is the 28,000 surety. And that's all we'll do for today. Thank you, Mr. Jordan.
Position 1, Mr. Brooks.
That is 26 CR 0000800G. Napoleon Brooks charged with 1 count of disorderly conduct, 1 count of criminal trespass, and 1 count of simple battery.
8 on probation, trespass, damage to property. It's 24 CR 008-017A. 2026 fade to appear, 2024 fade to appear. 2021 trespass NOLO, which is level 2. That's it.
Before the state goes, sorry. I had competency concerns, Your Honor, and I know he was going to be reset to Thursday. Do we still? I'm new to this per se. Do we still have the bond hearing before the competency? How does that go?
We usually do.
Okay,
We
cool.
usually set one and then put them on that calendar as well.
Okay.
Okay.
I didn't mean to overtalk. I just wanted to make sure I understood that procedure.
Oh, no, that's okay. Go ahead, State.
On February the 8th of 2026, officers went to Spring Street and North Avenue, Northwest, and he was standing in the middle of the street, vandalizing vehicles. It appeared that he had a stick in his hand and he was walking up to cars, striking the mirrors. He struck two vehicles, one belonging to a Jeanette Vasquez and one and Anna knew it. I don't want to murder her name. The last name is spelled Niezwaag. As a result of that, it appeared that he also was at the hospital. They were attempting to get a medical clearance for him, and he spat in the face of the nurse, Karnjeet, Karnjeet Young. Our bond recommendation for the for the disorderly conduct is for surety $1,000, criminal trespass a surety of $1,000, and for the simple battery, $1,500 or $3,500 surety. No further contact with the victims named in the case. No further violent contact in case he has to come in contact with the nurse, Miss Young. No alcohol, drugs, or weapons while out on bond.
And the nurse was at which location? What hospital?
At Grady. At Grady.
All right. Mr. Morrell.
Yes, before us is Mr. Napoleon Brooks. Your Honor, he is 21 years old. He is a lifelong resident of Georgia. Yes, a lifelong resident of Georgia. He actually does have one child, a 3-year-old, and he also has his GED. He's currently unemployed, Your Honor, but he does have a mental health diagnosis, bipolar. I think that speaks to and he also suffers with anxiety. I do think that speaks to a little bit of the simple battery. Even with my competency concerns, Your Honor, there was times where we had to actualize what's happening today, just kind of and where he was. I think that's important to know because that may be what have been going in through his mind when he was with Ed Grady. He may not have had the cognizance of understanding what exactly going on. I know that spitting is not it's not an excuse, but I think that with his disability, that may have led to how we got to the spitting, etc. Be as it may, I'm asking for a signature bond on this. I'm asking for a signature bond on the simple battery, 500 on both the disorderly and criminal. Unless his bond is posted, then no one will be able to post it. So that would be reasonable to ensure his appearance, which is the chief factor of bond, Your Honor. And then I'm asking that he's set for the excuse me, the competency calendar on, I believe they said Thursday.
Mm-hmm. I will give him the $3,500 surety bond, and that'll be 1,000 on the disorderly, 1,000 on the criminal trespass, and 1,500 on the simple battery. We'll set him for the competency calendar on Thursday. No drugs, alcohol, weapons, or guns while on bond. I am going to say no further violent contact with the nurse at Grady unless he's receiving services. Since he already has the diagnosis, I guess I won't order an MH or anything like that. They'll deal with all of that on Thursday as far as any treatment or medication. If he has any, he needs to stay on it, stay compliant with it. And I think that's it for now.
I just want to make y'all aware, y'all know this is sent 2 weeks Thursday, y'all.
Oh, 2 weeks Thursday. So that's gonna be the
26th.
the 6th, 3/6. Okay.
26th, the 26th.
Oh, 26.
Yeah.
Bill compensating on 2/26. Got it.
Mm-hmm. All right. Who do we have?
Position 23, Mr. Woodies.
This is 26 CR 001006F. Elijah Woodies, charged with 1 count of criminal trespass.
6. Got to open. Well, I'm sorry. Last arrest was for PI trespass. Dismissed. 2017 accessory after the fact. It went with a capital case. That was a conviction. I got a 2013 CWAC guilty. This was level 2. That's all.
Okay.
Okay. The state's bond recommendation is $1,000 surety bond. Stay away from 1210 Jefferson Avenue. No contact with Ernest Smith. I would ask for a social worker visit due to MH or suspected MH issues from a reading of the report. Very quickly on February 12, 2026, officers responded to 1210 Jefferson Avenue in East Point, where the homeowner Ernest Smith reported that Mr. Woodies had returned to his property despite having been previously issued a criminal trespass warning back on October 8, 2025. Mr. Smith stated that he found Mr. Woodies sleeping in the rear of his residence and that he had scattered trash throughout the yard, noting that Mr. Woodies repeatedly returns to the property after being released from jail. So due to the fact that he is continuously returned to this location, we are asking for a surety bond.
All right. Mr. Morrell?
Your Honor, it's my case.
Screen, sorry.
No, it's fine, Your Honor. Your Honor, I would ask if he is not able to make this bond and the bond that you set for him to be placed on the competency calendar on the 26th. But Your Honor, he did move to Atlanta from New York. He has lived now in Atlanta for about 6 months. And Your Honor, he is still trying to find employment, but he is 29 years old, Your Honor. I would, of course, ask for a bond as low as possible.
I'm going to order the $1,000 surety bond. Stay away from that Jefferson Street address or Jefferson Avenue. No further contact with the victim, Ernest Smith. We'll put him on competency for 226. Social worker visit to see if there's any other MH issues that need to be addressed before that calendar.
Thank you, Your Honor.
Mm-hmm.
No, I'm missing quite a few people.
Mm-hmm.
Oh, they're coming in. Okay.
Got some money.
I'm like, that
Well,
can't
I
be.
didn't know if you all had a lot of waivers, maybe.
I have some, but we'll see
Okay,
what
not
happens.
that many.
Yeah, there are some.
Gotcha. Okay.
Well, that must be a green clam. Oh, that's Griggs.
Position 6, Mr. Griggs.
Okay. This is 26 CR 000-815G. Aaron Griggs, charged with 1 count of criminal trespass.
24. 2026, DeKalb County trespass, simple battery obstruction. 2025, trespass, disorderly conduct. 25, shoplifting conviction. 24, failure to appear. 24, public intoxication. 23, trespass. 21, dangerous drugs conviction. I didn't see an address listed. It's level 3, that's all.
Yes, and you have an open criminal trespass and willful obstruction of a law enforcement officer. I saw them. I didn't see a disposition for him. He, on February the 7th, he was on a train at the MARTA station at the HE Homes location. He had received a suspension back in December in reference to an incident that occurred at MARTA. We're asking for a surety, $1,000, stay away from the MARTA locations in compliance with whatever suspensions are in place, that he meet with a social worker for housing before he leaves. No alcohol, drugs, or weapons while out on bond.
All right. Is this a suspension from all MARTA or just the station?
It's from all MARTA's
Okay.
locations.
All right.
And Your Honor, before us is Mr. Aaron Griggs. He's 42 years old, Your Honor. He did come to excuse me, sorry. He came to Georgia to live with his brother, Your Honor. He does have one son who is 11 years old, but does not reside with him. As far as educational attainment, he did graduate college and graduated high school and began some studies in college where he was studying psychology. He doesn't have any severe health diagnosis, no mental health disorders, but he has been in contact with the Dream Center. It helps with substance abuse, mental health, and other social services. Your Honor, it is my client's understanding that he didn't know that he had a 365 suspension. I would ask that, Your Honor, that this wasn't an act of violence against anyone, no disorderly conduct involved, Your Honor. I would just ask that you allow him to have a signature bond, Your Honor, and just reinforcing that he is not allowed to be on Martyr's property and using their services, in which we already discussed when I privately talked with him.
All right. I'm going to order a $1,000 surety bond. With that surety bond to continue to abide by the MARTA suspension, stay away from all MARTA. Social worker visit for housing, no drugs, alcohol, weapons, or guns while on bond. And I think that'll be it.
Position 9, Mr. Hugley. Have a seat on that back row.
This is 26 CR 001011E, Dante Hugley, charged with 2 counts of battery family violence.
27. Got an open.
Oh, go ahead.
Got an open battery DV 25 PI 004785. 06 ag assault, battery of a particular nature, crude 10 and 3rd conviction. 05 simple battery conviction, 2005 simple battery DV conviction, and the 05 simple battery conviction. It's level 2. That's all.
Yes, Your Honor. This incident occurred October the 16th of 2025. Officers went to 327 Lincoln Street Southwest in reference to a fight in progress. It appeared that the mother of the victim, Miss Morris, were contacting the police in reference to her daughter. Khana, Khana. I'm sorry. Melanie is her first name. That was her middle name. Melanie Hargrove. It appeared that her boyfriend Dante had attacked her after there was a delivery of groceries that did not go as anticipated at the home. He had hit her, according to her report to her mother, multiple times. The mother went to the location to pick up her daughter, and when she was there, she saw that she had bruising to her right eye and swelling on the left side of her head near her temple. She also had cigarette burn marks on her torso as well. The officers actually had to go to the Grady in reference to speaking with the victim in this particular case, Ms. Hargrove. She apparently had a seizure on the way to being transported to the hospital and was there when the officers arrived. She did not give any information, refused for the officers to take photographs of her injuries, but of course they were able to observe for themselves how she looked at the time of this incident, that this incident occurred. In consideration of, and when we look back at Mr. Hugley's history, his history began in 1996. It is full, as the court has heard, of repeated batteries, simple batteries, more than one occasion, firearms, battery, family violence cases. He has at least 2 convictions out of Fulton that I attempted to get documents for today. This is a case that we were looking for an open battery, and I believe that battery may be against this victim, and I don't have the documents at this time. I do have a police report that indicates that it did take place, that there was one that took place back in June of 2025. We are asking for a cash bond in this particular case. We're asking for a $5,000 cash bond as to each count. As to the significant injury, we will be seeking transfer to the DA's office in consideration of those cigarette burns that she had on her as well. We are asking for no further contact with her, and I understand that they may have been in contact since this incident, probably still live together, but the state's position is that she is in serious danger. Her life is in serious danger with this man. We are asking that he stay away from the 327 Lincoln Street Southwest address, as well as Ms. Morris and Ms. Hargroves. As to Ms. Morse's address as well, no alcohol, drugs, or weapons while out on bond.
Ms. Evans Battle, what was the bond amount?
$5,000 each cash, $10,000 cash bond.
Okay. And then you're muted, Judge, but I'm assuming you're telling me to go ahead. All right.
Sorry about that.
No problem. Before us is Mr. Dante Hugley, Your Honor. He is 52 years old. He's also a lifelong resident. The address of 327 Lincoln Street is my understanding that that is his home, Your Honor, and that he lives there alone. He also has 3 children, and he is currently working, Your Honor. He doesn't present with any mental health or severe health, Your Honor. As far as his criminal history, a lot of that is beyond the 10 years. I know the state mentioned that the history goes back to 1996, but of course, as we know, if this case was to proceed to trial, that would be more prejudicial than probative against my client, Your Honor. And then as far as the possible battery, we don't have the documents, and I think it would be very unfair to just speculate if it was against the same victim at this time, especially since the state does not have those documents at this time. Be as it may, Your Honor, a $10,000 cash, Your Honor, he would never be able to pay that bond. It'll essentially put him on a no bond status. What the Ayala factors himself says is that the chief factor is whether or not he will appear before court. We didn't hear many. I didn't hear any FTAs from the pretrial resulting his history, Your Honor, and so I would be asking for a bond to be set at I'm asking for a bond to be set at a $2,000 surety, but no more than a $5,000 because he would be eligible to go through what we call the bail project, which allows people to have their bond paid for, but the total bond cannot exceed a $5,000. Otherwise, he would not be eligible. Hold on, Mr. Hugley. I see your hand up. But if you're getting ready, if you want to speak about the case, I would strongly advise against you. Anything you say could be, hold on, I hear you, but they're going to unmute in a second because you have a right to speak. But anything you say can be used against you. This line is recorded. You also have two prosecutors on here who could use your statements against you further down the line. Now, if you have questions about the bond, the judge has not ruled yet, but I would advise you not to speak about the case per se. I don't want you to make incriminating statements. Okay.
All right.
He still, I think he still wants to speak. So, courtroom two,
You
can
want
I?
to speak before I rule?
Oh no, man. I just was saying like I don't have the money to like pay no high bond. I've been on my job 7 years, but I only make minimum wage. So like I was just agreeing to what he was saying. I can't pay a $5,000 bond. I can't do that.
Yeah, and my fear is that we don't want him to lose his bond. That's why I was checking before we got here about his eligibility with the bail projects.
All right. I will order a $10,000 surety bond, 5,000 on each charge, based on some of the alleged allegations. No further contact with the victim in this case. And what I allow is a sweep of that property to make sure that the victim doesn't live there when he gets out, to have a police escort. The victim does not live there, then he can reside there in his home. But if she does have things there and it appears she lives there, then he must stay away until she moves or vacates that property. No drugs, alcohol, weapons, or guns while on bond.
Any way you can reconsider to do a 5,000 so I can submit a referral today?
I want to make sure, State, did you all talk to the victim or not?
We have not spoken to the victim in this particular case. Let me see if there's an update.
And with the bail project, while she's looking at that, it's not like an immediate pay. It's kind of like you do the referral, then next week when they get back in office, they do an assessment. So they'll have times before they actually even post a bond. But 10,000, they would just deny them all the way.
Well,
I'm concerned about the victim though.
yes, and we've not had an opportunity to speak with her, but besides that, you know, we were asking for a cash bond, and you know, our concern continues to be the safety of the victim. This repeated history, you're saying that it's only that it's been more than 10 years. It is repeated history of violence against people all the way up until and we have an open family violence case. I mean, the officer even indicated they had been to the home on previous occasions. So, you know, we're, you know, if the court is going to order the surety bond, we would just ask that it be ordered at the $10,000.
Okay. I will leave it at the 10,000 surety and make sure this victim is safe. No further contact with her at this point. And the only way he can stay at that location is they sweep it first to make sure she does not reside there. All right.
You can unmute courtroom too.
Okay, I don't understand. What is a $10,000 insurance bond? I don't understand it.
You can talk to your attorney about that after court.
After court, how can I do that?
I'm gonna call over there if the next person is not mine. It's Mr. Hugley. No worries. Is that all in courtroom too? Because I can call over there to
This is
speak to
19
Ms.
and 20.
I'm sorry.
19 and 20.
Oh, I don't think those are mine. I'll call and speak with Mr. Hugley.
Okay.
And I'm sorry, Mr. Howard, you said you had a case number for an open battery?
Who said nothing?
You didn't say that?
What you talking about?
On
What cases we
Hugley.
talking about?
On Hugley, do you have a case number for an open battery?
25 PI
Okay.
004 785.
Thank you.
All right, this is 26 CR 001012G. Brian Stewart, charged with 1 count of battery family violence. And 26 CR 001018G, charged with failure to obey traffic signs and traffic signals or light.
28. We got an open suspended license out from the city. 1, 2, just 2 of them. I got a 25 CR 003 495G suspended license window tint. Got an open identity theft fraud out of Fayette County. On probation out of Houston County for identity theft fraud. They gave him 10 years probation last year in April. This was level 3. That's it.
I'm sorry, whose name did you call?
It was Brian Stevens.
Stewart.
Or Stewart.
Okay.
Now, the state's asking for a $5,000 surety bond, no further contact with Rachel Jones, stay away from 2869 Hateville Road, Southwest Atlanta. And the allegation is on October 5th, 2025, officers responded to a domestic disturbance at that location. The victim, Rachel Jones, reported that during a verbal argument with her boyfriend, he struck her in the vehicle. He later choked her with both hands to the point that she could not breathe. She also stated that he then left the scene after her mother called the police. The officers observed and documented injuries to include bruises near her mouth, a busted lip, and scratches around her neck. The state is going to ask if we're able to seek to see if this is something that can go up to the DA's office, but due to the time, it is a battery family violence right now. And we are asking that it be a $5,000 surety bond. No drugs, no weapons, and no alcohol while on bond.
And so that was 5,000 on position 19, the battery family violence. And then what was the recommendation on the traffic?
The traffic offense, I think, already had a $500 surety bond. I'm just asked that it remain the same.
Oh, okay. Okay.
And let me make sure. I believe it already had a $500 surety bond.
Okay.
Is everybody frozen or am I still here?
No, I
Okay,
thought you were.
Let me tell you something. Y'all were the most still folks, both you and Judge Mincy. I'm like, is my internet off? It says no bond, but I mean a $500 surety bond or a $500 SOB to the jail on the traffic offense is fine.
Okay.
And Your Honor, so of course we don't oppose the $500 signature bond on the traffic offense, but Your Honor, we would ask for a bond as low as possible on the family violence battery, Your Honor. Your Honor, he lives in Decatur with his aunt. He's lived at that same address now for 5 years. Your Honor, he does marketing for A1 Recording, and he has had that employment now, Your Honor, for 10 years. He has graduated high school. He completed 1 year of college. Your Honor, he does have an adult child that is 18. That child lives in Kennesaw, Your Honor. And he does have, as stated, significant family ties. He lives with his aunt. He has another aunt that lives in Conyers. His child lives in Kennesaw, and he's had employment now for 10 years. And from reading of his criminal history, this is the first allegation of violence, Your Honor. yes, he does have a felony conviction, Your Honor, but it was for fraud. There's nothing that was read in his criminal history that indicated violence. So we would ask for the family violence battery bond to be as low as possible, Your Honor, so that he can maintain his employment.
And the victim, Rachel Jones, state, what's the relationship, or do we know, former girlfriend or what?
It was his girlfriend.
Girlfriend.
But from my understanding, Your Honor, they do not live together.
All right, I will, on position 20, Ms. Lewis will do the 500 signature bond through the jail. And on 19, I will leave it at the 5,000 surety bond due to the number of cycles. I know they may not be violent, but 28 is pretty high. No further contact with Rachel Jones. And this incident location, did the state ask for a stay away?
I did. It was 2869 Hateville Road, Southwest Atlanta, Georgia.
Okay, we'll stay away. 5,000 surety. No drugs, alcohol, weapons, or guns while on bond.
That's all I have in the courtroom, Judge. We can do the waiver cases.
Okay.
Position 2, Mr. Carter.
2. Okay.
But Your Honor, if we could, I have the bottom of the calendar. I don't know if Mr. Morrell is still talking to Mr. Hugley. So,
Looks like he might be. Yeah.
so if we could take one of the
Okay.
waivers that are
At the back, we'll start
yes.
from the back.
Yes.
22. Is it Bertha Williams?
Your Honor, we're asking Ms. Williams to be placed on the competency calendar, to be reset to the competency calendar.
Okay, that's 26 CR 000970F. What's the state asking on bond?
$1,000 surety bond has already been set. We would ask for it to remain the same. Stay away from Georgia State University and
Okay.
SW. I'm not sure what that is. I'm sorry.
Social worker visit, I think.
Social worker visit. Yeah, thank you.
Okay. All right. The $1,000 surety. Put it on the competency calendar for 2/26. And stay away from Georgia State. Social worker visit as well.
And that's position 22, Judge.
Yes. Then we'll come through to, let's see what's next.
21.
Okay. 21 is Connery Wheeler, 26 CR 000988E. 1 count of criminal trespass, damage to property, and a 2nd count of just criminal trespass.
Six, on probation for simple assault, ag assault. It's out of Clayton County. 2024 firearm charge that was dismissed. 2020 simple assault conviction. It's level 2. That's it.
Okay.
You know, on this one, the state would ask for $1,000 surety bond is already set. Stay away from MARTA and a social worker visit. He has a male has a permanent MARTA ban. He kicked in a glass door at a MARTA fleet building.
Screen.
And Your Honor, Mr. Wheeler is homeless, Your Honor, but he was born and raised in Atlanta. When he's able to get work, he of course does odd jobs, Your Honor. He went to the 9th grade, and his family does live in the Atlanta area, Your Honor. We're asking for a bond as low as possible.
Right, I'll leave it at that 1,000 surety. Stay away from all MARTA. Social worker visit, you must comply with the ban. No drugs, alcohol, weapons, or guns while on bond.
What is that breakdown?
500 on each.
Thank you.
Mm-hmm. And let's see. Next we have is a 17. This is 26 CR 001004F. Aaron Robinson, one count of criminal trespass.
A resident of Mobile, Alabama, on probation out of state court for PI. On probation out of Cobb, simple battery. Probation out of Fulton for simple battery and trespass. On probation out of Fulton for a single simple battery. On probation out of Fulton for simple battery and simple battery against police. This is level 2. That's it.
And state's recommendation is $1,000 surety bond. Stay away from 106 South Main Street, Alpharetta, Georgia.
Okay.
And Your Honor, Miss Robinson is 37 years old. She is currently homeless. She does have an uncle that lives in Columbus. Her family is from Mobile, Your Honor. She does receive SSDI, Your Honor, due to a mental health diagnosis. Your Honor, it does seem that she is receiving her medication through Grady. But Your Honor, given what I was able to obtain from her, I would also ask if she could be please placed on the competency calendar on the 26th as well, Your Honor. But it does seem that she may be set up to receive her medication through Grady. Your Honor, of course, we would ask for a bond as low as possible.
All right. And Ms. Hargrove, which case are you here for?
Your Honor, she's here for the
Dante
Dante
Hugley.
Hugley. I was going to ask if
Dante
we can
Hugley.
revisit. Whenever we get a chance, we don't have, if we're doing the waivers, we can revisit whenever you're ready.
Okay. All right.
Just
you can
have a seat, Mr. Dante. Just whenever you're ready, Judge, we can continue doing the waivers.
Let's look at on this one, which is Robinson 17. I'll leave it at the 1,000 surety. This one's going to competency as well. Stay away from the Alpharetta location. No drugs, alcohol, weapons, or guns while on bond. And I think that's it. Was there any no further contact with the victim on that case?
It was a criminal trespass at a Taco Bell, so we just asked for the stay away.
Okay, just to stay away.
What was that?
1,000 surety. All right, and what are we asking to do at this point?
Go to Mr. Hugley first.
Hugley.
Yes, Your Honor. So I know that we have addressed, I'm just getting back to my notes on Hugley. We addressed Bonnie, you said it at a 10,000, Your Honor. I just spoke with Miss Melanie Hargrove. That's the victim in this particular case. And I also spoke with Mr. Hugley about this more about this incident. Miss Hargrove indicates that she also is not opposed to him being released. She also says she does not fear him. She wants him to be able to get out, Your Honor. She made herself, I'm the one that provided her the Zoom link so she can be able to log on, so she can be able to speak to you directly. She indicated that she wasn't the one who called 911. I think I understood that to be correctly when I briefly spoke with Ms. Hargrove. And since she is a victim, I believe she wants to make a statement.
All right, Ms. Hargrove.
Yes, so that incident.
Hold on. It's to swear you in first. Raise your right hand, please.
Okay.
I usually don't go back over it, honestly. So I'm going to ask you 2 questions, and that's all I want to hear the answer to for today's purposes. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, put your hand down for me. Are you in fear of Mr. Dante Hugley?
No.
And do you want to have any further contact with Mr. Hugley?
Yes.
You know, there's a
Okay.
current stay away under the 25 PI case, so he can't have contact with her either way. That he has the 5,000. He has a $5,000 good bond, and there is a stay away ordered in that case from her and the 327 Lincoln Street address.
Okay, he's already under a bond. Ma'am, are you aware of that?
She is the victim in that
I
case.
I did not know about a stay away, no.
Did you go to court on that case?
No.
Okay, well, that's probably why you don't know, maybe. But you can get a copy of it. And so on this case, I think I gave a
$10,000 bond, and I would just ask that if you can reduce it to the 5 because she doesn't want to have. She's not in fear, but it would also allow for him more so being able to give Mr. Hugley an opportunity to be able to actually bond out. It's not about having contact, but more so getting a bond set so he can be able to get out of custody. Because the $10,000, he won't be able to get out of custody, and I fear he'll lose his job.
I don't know that I'm worried about him losing his job. I'm worried about him to not have any more cases with this victim and getting
Can I
out.
say something?
That would be our concern, which is why we brought the case. We understood that Ms. Hargrove did not want to prosecute this case, but in looking at the facts, looking at the facts and the information that was contained in this, the state continues to be concerned for her safety. And that is why we are prosecuting this case.
And I understand that. I guess from my point would be that whether he pay the $500, I mean not 500, but he pay $5,000 or having to pay $10,000, it achieves the same goal. It shows that he can come back to court. The state can still make sure that she's protected, etc. But it's about the ability that this poor man, whether or not he'll be able to get out of court. Whether for a poor man, whether you place a $5,000 bond or a $10,000 bond, it's still an enormous amount of money. It doesn't make the difference. It doesn't change his ability to have some kind of skin in the game, but his ability to be able to get out drastically changes. If you have a 10,000, he'll never get out. Versus the 5,000, he will be able to get out. And the chief factor of bond is not to punish him against allegations that hasn't been proven, but to ensure his appearance before court.
As well as the safety of the community and the victims in any case. I mean,
Right, but I was just saying that the chief factor under Ayala is to ensure his appearance before court. Surely, if Ayala, who was charged with felony murder, can get out of custody, surely Mr. Dante can get out of custody with battery.
Well, if he is it 10,000 surety, so 20%, still it's only 1,000. I hear you, but this is the third case with this victim, is it?
This is at least the second case with the victim that I'm aware of, but he also has that open firearms case as well, and which is a separate incident. So it's not as if he is not out in the community all these 30 years not doing anything. There still continues to be a need for the public to be protected. And one way in which that can be done is by setting a bond sufficient for him to get a bondsman and be able to get out, but also to deter his ability to repeat his offenses, and particularly his offenses against the specific victim.
And I guess, and this is my last thing, and I'll let you rule, Judge, is that when it comes to I got this, Mr. Hugley. When it comes to Mr. Hugley, the issue is with this 50-year-old man. He's not like myself, where at 36, I have best friends, I have mothers that can be able to pay the bond. Since he's sitting in custody, he's going to depend on the public defenders and their social services team to be able to try to get him out. And so that his only support and lifeline is going to be through our office, and our arm is going to be through the bail project. However, he will not be able to have a lifeline to be able to pay the 1,000 good bond, in which the state wants to be able to afford him to get through with the fees and surcharges, etc. His only shot and chance is to have a $5,000 bond. Well, the bail project will also monitor and supervise him to make sure that he abides by all of your conditions.
Right. I don't I want to protect the public and protect the safety of this victim. And due to the allegations that I've heard, not sure about that yet, so I'm gonna leave it at the 10,000 and come back for review, but I'm just not confident about the safety of the victim if he were to get out under the bail project with 5,000. With he has 27 cycles, and I think that the 10,000 surety is fair under the circumstances at this time.
Okay, Judge.
All right. Thank you, Ms. Hargrove.
Judge, does she live at the Lincoln residence? Or used to want who did that verification? Can you verify that with her?
Ms. Hargrove?
Oh, yes, I'm sorry. Hold on, let me pull it back up. I thought you were done with me. Oh, where is it? Okay. I'm here.
What again, Ms.
I'm here.
Lewis?
Just before I write all that stuff up, if she lives at the resident, you had him to have a police escort to verify if she lives there or not.
On this one?
Yes.
Oh, he said that this was his home alone. What is your
Yeah.
address, Ms. Hargrove?
It's 1362 Chambers Avenue, Atlanta 30344.
And I don't remember what was the address on that one, Ms. Lewis.
327.
Yeah, it's his place, his residence.
Just so you know, before the other felony bond order has a stay away from 327 Lincoln Street Southwest. So there's already a stay away in place.
And that's his home, but she's saying that she doesn't even live there. So he's trying, and when he be able to get out, he wants to get back to his home. I mean, granted, we have to address it on both, of course.
Sure. He probably should not go back there because there is presently in place a stay away from that address. He shouldn't have been there in the first place, to be quite candid, because there's a stay away. And until this felony bond is modified, he probably should abide by those conditions.
Right. I'm not going to modify that. So he's got to stay away from that address until he can get the felony bond modified.
Right, because it's my understanding that they believed in the felony case that she lived at that address, but she's showing that she doesn't stay at that address. So what I would ask is that this order not have the stay away, and then I will contact the PDs that is assigned to the Superior Court to try to be able to get that bond lifted so that we don't have to work double time and backwards.
You know, at the time of this warrant, it said that they lived together at 327 Lincoln Street Southwest. That was the incident location. It was the location from the June incident. So,
but Your Honor, people are transient, and you
are,
heard
and we
from
still
Ms.
are asking
Hargrove that she doesn't live there. You asked what her address was. She gave a Chambers Street. That's not the incident location.
Well, because it was the previous address, I don't know. And this is a victim who I don't know that she's very cooperative or not. It seems like she isn't. And so, you know, people come and tell us a lot of things, even though I put them under oath. Right now, I need to make sure that she's safe. And until you can find specifically that they don't live together or won't be residing together, because don't want to have another case here because we didn't take the right precautions. And I don't know, how long have you been at this new address, Ms. Hargrove?
It's not a new address, it's my mother's address. I've been living there since after the first incident back in June or July, whatever it was.
Then we had another one, correct? ASG
I was visiting.
You were visiting? Okay.
Yes.
Well, I'm going to leave it the way it is to make sure you don't visit after if he gets out this time and we have another case. We're trying to protect you. But you may not say that you live there, but visiting and maybe staying a little too long, then obviously you get into some issues, and then we're back here with another case. We're trying to protect you right now. So until there can be some more investigation or information on it, I'm just going to leave the stay away for the moment to err on the side of caution. All right.
Well, let me get this clear so I write this bond up correctly. You have a $10,000 surety, $5,000 on each charge. No further violent contact with the victim, and the defendant to stay away from 327 Lincoln Street, Southwest Atlanta, Georgia. The defendant may remain at the residence if the victim has vacated the residence once law enforcement officer verify
Was it no further violent and no further contact? I wrote no further contact. I don't know.
No further contact.
Yeah.
But I just want to make sure, you said one-time return with law enforcement officer to verify the victim has vacated the resident and no longer lives there. And
If they sweep it and she has no items there.
And just so the court, oh, go ahead, Miss.
Okay, the issue is going to continue to be that he's already been ordered away from the 327 Lincoln Street address. So he cannot go back there until that is modified. And at this point, it has not been modified. Therefore, we're asking for that to remain the 327 Lincoln Street, as well as she's advised of her address on the Chambers Street address also. And we would ask that include that, because that is where she lives and there's no further contact with her.
Your Honor, and it's for the sake of efficiency, Your Honor. I'm okay with using the new address and saying, stay away from, her mother's address. But if we're going to then go and have the Superior Court attorney to address the address issue, then we're going to have to circle back to try to get this lifted. And when we could just simply stay away from the victim, they still have to stay away, and then we're double working to be able to allow him to be able to go back to his home, because we're surely going to have to, the stay away, if the state is concerned with the stay away from Lincoln, is still in place, in the Superior Court judge will hear our argument, they'll hear from the DA's office, and then they'll be able to lift it. If you put it in your order, now we have to not only hear before the Superior Court, but then try to get a hearing in front of some judge in state court to be able to hear the same arguments from two different states' offices. And I would just ask for efficiency, since it's already in the stay away at Superior Court, let us just battle it out in Superior Court.
And Your Honor, just to reiterate, you did put in place that the law enforcement can sweep the place to make sure that she is not living there. So now you not only have her testimony under oath, but you also have law enforcement officer verifying that she does not live there any longer.
And we would have a competing bond orders, one that says he cannot stay there, and one that you're saying would give. So we certainly don't want the court to create a competing bond. He can't go back while that felony bond order is in place.
But
so once you get the felony bond lifted, once you get the felony bond changed or modified and that is lifted, then then you can bring it to the state court. I don't want to give a bond right now that is conflicting with the Superior Court bond.
Can we be silent on the
matter? I know what you're saying. If I lift this one, it'll help you go to the Superior Court so that they can lift that one. I'm not so sure, but I would change and err on the side of caution right now. Not for sure who I believe or what I believe in it, but I do know that I want this victim to be safe. And we're watching out for her. If she doesn't understand it, she will by and by. But I don't want it to right now be contradictory.
We're not asking for it to be contradictory. We're just asking for you to stay away unless law enforcement can verify that she does not live there.
But that contradicts the Superior Court order right now that says he must stay away. So it is contradictory. Because right now the Superior Court order says he must stay away, right? And then I'm giving one that says they can sweep it and he can go there. That's contradictory.
Or we can be silent on this matter on the bond order, and then we just hash it out in spirit. It doesn't have to.
Well, if I'm silent on it, then that means he can go back.
No, but he still he would not be able to go back because the Superior Court judge has to stay away from it, and surely the bonding office will revoke his bond. And so therefore,
what do you want him to be silent or say he can't go back?
Stay away from 327, as it was indicated earlier. That was the incident location, and they said they resided together in October, certainly after the June incident, when Ms. Hargrove today has indicated she moved out of that location.
And then they were both there in October. She said she was just
correct.
visiting. Okay. I'd rather protect Ms. Hargrove and order that he stay away from this location right now. And then if you get the Superior Court order, then you can use that. If that portion is lifted, then you can bring that to state court for it to be taken out of this one. I'd rather it go that way, and I know it may be inefficient, but again, we are trying to make sure that she doesn't go visit, let alone go try to stay and live there. We all know what generally happens, honestly. And, rather than going deep into that, I just know what generally happens. And then we have another case, or she's not here to talk about it. So until we can get it all sorted out in the Superior Court first, then we're going to have him to stay away, and continue to honor the Superior Court stay away as well. And I'm not going to let them sweep it and have it contradict. So I'll take that part off and just have him to stay away right now until all the bonds are modified, how many ever there are, 2 or 3 or 4. So let's just have him stay away until we can get a handle on it. Okay? Thank you all. Who do we have next?
Well, on my calendar, I have oh gosh, my computer is doing
Mary Holloway.
I didn't interview her. Did you speak with her, Ms. Green?
I did not.
Yeah, and she wasn't at ACDC. I spoke to all the ladies in ACDC.
So did she bond out or anything?
No, I know she did bond out. I know she didn't bond out.
They had some that were in transit.
Oh, some
we
were
were not able to speak to.
Okay, so we need to do that. But maybe if we were going from the back, because Mr. Morrell was on the phone, I think 15 Parker.
Hey, Holloway is at ACDC.
That's an inmate reset.
Is she?
Okay, so I was told that that's a mental health reset.
Yeah. She said,
Oh, 5 is a mental.
she said.
Which one's a mental health reset?
Mary Holloway.
Oh. All right.
It's reset from yesterday.
Yeah, she was reset from yesterday.
So I'm just letting y'all know, keep an eye on it. Because we
Mhm.
have all these multiple resets from this counter from a lot of previous SEA counter. I just don't want them to get lost in the system.
Yes, and she's ultimately probably going to, she's already on a competency calendar
Oh, she is?
for felony cases.
Oh, you got me scared there for a minute. Like, I don't remember putting her on one. So this is just going to go back. This is going to go back on for Monday then, huh?
Yep.
Yeah.
All right, who do we have next?
I don't have any indication on
Okay.
Floyd
Floyd James.
Yes, John. And if I can get my computer going,
Oh, you mean James Floyd?
James.
Oh,
Floyd.
James, we said it
Correct.
backwards.
Sorry, and his presence is waived.
Oh, okay. So we can do that one. Let's do 5. James Floyd, 26 CR 001010C, criminal trespass. What do you have, pretrial?
Floyd, 16. He got an open burglary out of Muskogee County. 2 probation violations from 2025. This was level 3. That's it.
We were asking for $1,000 surety in this case. This was a criminal trespass at the Jane restaurant. He was found there. He had already been told the day before not to come back. And he was in the hallway, laying in the hallway, mumbling inappropriate language. We asked that he see a social worker for MHBH, no alcohol, drugs, or weapons, stay away from the property location at 437 Memorial Drive.
Just 1 second. I'm sorry, Your Honor. My computer is doing its own thing.
Gotcha.
Okay. We are waiving his hearing. We do want him to be set for the mental health competency. I think Ms. Lewis said that was on the 26th. I think I may be making things
Have
up.
we reached our limit, Miss Lewis? She's gonna tell us in a minute.
Yes, I'm getting ready to tell y'all that. Yes,
Because I think
y'all.
we
Yes,
put a
you
lot
have.
on it.
I'll make adjustments. We may have to do an add-on. I don't know, Mr. Jordan, what you think? We may have to do an add-on for next Thursday calendar. But we do have a big calendar on Thursday, so I just didn't want to overflow it.
Right.
But yeah, well, I think we are going to reach our max for the next 2 weeks out.
Okay. I would be asking for. Okay, so well, Judge, let me ask this before I make my recommendation. If I ask for a signature bond and you ruled in the signature bond, he would be released and wouldn't go to the competency. Is that correct?
That is correct, right? Yes, I'm sure that's correct.
Okay. I would ask for a $500 bond on this particular case, and then allow for him to be able to go to the competency. There is some, I believe that he needs some supportive care, but just a little bit about Mr. Floyd. He is 56 years old. He has a valid address out of Columbus, Georgia, and he does have some ties to Fulton County, but his main support is in Columbus. He did have a job prior to in custody, or let me say he's done like auto body work kind of through a contract under the table, and he receives SSI. Um, he does have a mental health diagnosis, possibly, Your Honor, and so I would ask just for a bond to be set no higher than 500, allow him to go to the competency.
State.
That's fine, Your Honor.
Okay. All right. We'll do the $500 surety and put him on the competency. No drugs, alcohol, weapons, or guns while on bond. And to stay away from that Jane restaurant on Memorial Drive. And that should be it.
And then I have one last one, which
Okay.
is position 2, which is Carter. And let me just double check one last thing. I have his presence wave. And okay. We're not asking for competency on him. We're just asking for about he just waived his presence.
Okay.
Right.
So 26 CR 001002G. Thirstin Carter charged with 2 counts of simple battery family violence. Retrial.
It's first level. That's it.
Okay.
Yes, Your Honor. On February 12th of 2026, officers went to 1132 Maria Head Terrace in East Point. The victim in this case is Mr. Carter's mother. Her name is Gloria Carter. He punched her in the stomach. He hit her on her shoulder so hard that he knocked her into a table on the ground and broke the table as she went down. This was all because she had sent him to the store with with a card and some money to get something from the store. He came, and that was at about like 2:30 in the afternoon. He came back at 7 o'clock in the evening. He didn't have the groceries. And she was going through her purchases to see what he had purchased. She knocked on the door to his room and was asking him what did he spend the money on, and he became angry. I am concerned that the victim in the case has spoken to our office. I believe I see a Carter on the line. The victim in this case is 70 years of age. And I know that Mr. Carter is about 47 or so. So our bond recommendation is actually for a surety. I understand that this is his first offense, and the court may be inclined to give him a signature bond. But I think for the protection of the mother who is in the home, would be in the home with him, that is our concern. So we're asking for a $5,000 surety. That's $2,500 on each count. That he have no further contact with Gloria Carter, and she'll be able to speak for herself, that he stay away from the 1132 Maria Head Terrace, East Point address, that she indicated that there may be some mental health issues. He does have a diagnosis. And so I would ask they see a social worker before released and have no alcohol, drugs, or weapons while out on bond.
Okay. Miss Carter?
Martika Carter. Wait, you have to unmute. Oh, and then it's Gloria Shavers. Oh, well.
Yes, but I'm Gloria Carter Shavers.
Okay.
Martika Carter, she was on. I don't know what happened.
And who is Martika Carter?
My
I'm her granddaughter.
Okay.
Gloria Carter Shavers is my grandmother.
Okay, but you're not the victim in this case,
I
correct?
am not.
Okay, so I won't be able to speak with you today.
Okay.
So we'll just talk with Grandma
Yes,
Gloria Shavers.
thank you.
Raise your right hand for me, Miss Shavers. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
And do you have someone behind you?
That's my daughter.
Okay.
Take my hand down.
Yes, take your hand down. All right. And you are the mother of the defendant,
Yes,
Thirstin Carter?
yes. And
All
all I
right.
want is my son back home with
Hold
me.
on a second. Let me ask you a question. Are you in
Yes,
fear of
yes.
are you in fear of him?
No.
Okay. And do you want to have contact with him?
Yes.
Okay. And I heard the allegations, and they sound
I
pretty
am.
serious.
I'm sorry, Judge.
Don't cut me off. Listen to my
Yeah, I didn't mean to
question
do
first.
that.
Okay. So I heard the allegations, and I know at this point they are allegations. And so they sound pretty serious. And so you're saying you're still not afraid of your son?
No, because I'm not hurt. I'm his caregiver and his mom, and I'm not hurt.
Okay.
And I need to help my son. We're just in the middle of waiting on an appointment. They're gonna try a new medical procedure with him. It could go either way. It could better his condition, or it can and I want to get him to that appointment because all these many years I've been trying so hard to help my son and find help. It's just that he lost it and whatnot. But being that I'm not hurt, I don't want him to go back to jail. I want him home with me. So, I can do what I need to do to get all the help I can for him. And he got an eye appointment in 2 days. He got a clinic appointment in March. He had to see the neurologist in April. And the procedure is due to take place in we had to leave Grady's and transfer to another hospital because they don't take our insurance no more. So we had to be placed at another hospital. But I have a new doctor, and that procedure I want him to have. He wants.
When is the procedure supposed to take place?
Okay, September.
Does one of your granddaughters know that?
No, but I can go and get it and then I can give you well, it's right here written in this
I'm
book.
aware of it, Judge.
Okay.
I'm aware of it.
All right.
Okay. Martika,
Okay.
raise your right hand.
It's September.
Oh, okay. What is it?
Oh, okay. I didn't want to talk cross you.
Go ahead.
It's September 2nd, 2026, 10 a.m. And the doctor gonna, that he'll be seeing is a new doctor now. Doctor.
You
Yeah.
have to give me the name.
Okay.
All right. So he has a procedure that's not until September.
Yes, ma'am.
This is February.
But yes.
Okay.
Yes. And then, I want to just go through with going to our primary care doctor. We got an appointment next month for that. And we got an appointment for him. I need to take him to finish up at the eye specialist.
Well, let me say this to you. In the meantime, he has all these appointments, but we want to make sure you're safe.
Yes,
Okay?
I'm not
And
afraid
that
of
is the
him.
kick.
And it's just that he, imagine not being able, Your Honor, to not being able to taste food or smell. And that's been going on for a long time. And he had hope of being
Okay. But
okay.
if that's going on, we don't want him hurting you in the meantime because he can't taste or smell.
Oh,
Martika, I'm gonna
but
give you
then
2
I can
seconds.
give you other diagnoses that's wrong with him if you want to know.
No, because that
Okay.
right now I'm not going deep into that. This is not his trial.
Okay,
Martika,
but
I'm gonna give you 2 seconds. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes,
All right. Are you in the fear for your grandmother when she's around Mr. Carter?
I'm not.
Okay. And do you think she should continue to have contact with him?
I do.
Okay. All right. Thank you.
Your Honor, if I might just ask Ms. Schaefer's, when the officers were in the home, isn't it true that you informed the officers that at that time that you were in fear for your safety?
At that night, what he had done, what had happened, the incident, yes, I was afraid, but I'm no
Okay. Do
longer
you live
afraid.
alone or do you live with someone else besides him?
Just me and him.
All right. Is there
How
somewhere
close
else
are
that he
your
can go to?
granddaughters? And I'm sorry,
I was just asking, is there somewhere else he can go and live?
No, not that I know of. My daughter don't live too far from me. She has a house not too far. And well, my granddaughter, which I give her power over town, power of. I'm sorry. Okay, so it's,
All right,
but
then.
they both work long hours
That's
and
all I
whatnot.
have.
But
Thank you, Ms. Schaefer's.
yes,
Thank you
ma'am.
so much. And Judge, the state's position remains the same in reference to at least that they should not live in the home together if they're just here by themselves. Thank you.
all right. Mr. Morrell?
Yes, Your Honor. So not before us, but his presence is waived. He's 46-year-old. 46-year-olds, Your Honor. He's been living in Georgia over 10 years, Your Honor. As you heard from the victim herself, she wants Mr. Carter to be able to come back. Mr. Carter doesn't have an extensive history. He doesn't have a pattern or significance of committing violent acts. He actually doesn't violate any of the 4 factors of Ayala, Your Honor. He doesn't show a significant risk of fleeing from our jurisdiction, a significant risk of being a danger to our community, whether it's a person or property, a risk of intimidating a witness or the risk of even committing a felony. We do have one chance that I would ask for a signature bond in this particular case, given that this is his first arrest. Your Honor, I'm sorry, he has 1 cycle, so this may be first or second arrest, Your Honor. But I would ask that you allow him to be able to go, oh, this is his first arrest. Sorry, this is his first arrest, and that allow him to be able to go back to the home as even when the state was indicating that they don't want him to be there. Miss Carter showed a face of sadness, and even now she's showing emotion of praying that you allow her to have or allow Mr. Carter to have a chance to be able to show himself as being able to have no further violent contact. Many of the accused have a no violent contact provision. We would just ask that Mr. Carter is provided that benefit. We understand if he picks up another case, which we hope that is not the case, God forbid, then we know what the condition would then ultimately become. But we would ask that since Mr. Carter has not shown a pattern of committing any batteries, they don't have a history of going back and forth with any family members at all, that this may just be one isolated event that we're going to need help. Now, what I would ask is that if you are allowing it to go through a signature bond, I would ask that you put in the signature bond with the wraparound so that the social workers in the pretrial can be able to keep in touch with him as well. Nothing further.
I'm going to err against my better judgment because the one thing I thought spoke volumes is that Ms. Shaver was scared in that moment for someone to get thrown over a table, for someone to get hit for someone, of course they are fearful, and they should be. And people will come to this court under oath and tell me, no, I wasn't scared. Almost got my back broken, almost got my shoulder broken, almost got a black eye, but I wasn't scared. Oh, yes, you were. That's why the police were called. I get it. And do we want to make sure it doesn't happen again? Sure we do. But these appointments are far out, and you got a long time to go in between these appointments. So I'm going to hope that you will be safe. But we're here to protect you, Miss Shavers, and we're trying to do that. And I know it is your son, and it's your baby. We get it. But sometimes, you just can't live with them until they get some treatment. So hopefully you get that treatment sooner than later. So I'm going to give him a signature bond through pretrial. So he's going to have some monitoring going on. So it'll be a $5,000 signature bond through pretrial, $2,500 on each. So if he comes back, it'll be doubled. The bond will be. And he's to have no drugs, alcohol, weapons, or knives or anything like that while on bond. There's no further violent contact with you. And I'm trying to see what other wraparound services. I know that Mr. Morrell mentioned that through pretrial, or what other services do we need to order? He's already diagnosed, so whatever treatment that you all find for him, he needs to comply with that treatment and take the medication. If he doesn't, then that could be grounds for revoking his bond if he doesn't cooperate with the treatment or take the medication.
In Tucson, or Mr. Howard,
Yes.
if the order says wraparound, that means one of the social workers in your department will have to be in contact. Is that correct?
Yes. I mean, you don't have to be wraparound, so you could just order pretrial.
Okay.
What's the level?
Level 1 or 2. Well, if he's going to be treating, I guess level 1.
All right.
Hold on, Ms. Gloria. You have to act. The judge may address you, but she's speaking with pretrial.
All right. And so let's make sure that, I don't know if the social worker needs to see him as well, but just want to, again, we are here to make sure that the family is safe under these circumstances. One last thing, Ms. Shavers.
Yes. Yes. Yes, Judge.
Did you want to say something?
Yes, ma'am.
Go ahead.
Yes. That appointment in September, that's for a new procedure they want to try on him and whatnot, because the doctor said it may be to his beneficiary, or it may go the other way. But all in all, it's better for doing it, because if he don't have it done, his brain will shut down and he's going to die anyway.
Yeah, sorry to hear that, but I hope
Please
it
let
works.
me have it. Please let me have it back. He do have a 2-day for the eye appointments. I try to take him to all his appointments.
Well, I'm giving you a
I'll be
signature
more
bond, so
scared being here living. I'm sorry, Judge. I'm sorry, living here by myself.
well, you said
And
your
with him.
granddaughters were close by. I'm sure they check on you.
No, my granddaughter's not close by. My daughter is closer by, but
Okay.
she doesn't have a car at the time. And
Well, I hope she
granddaughter,
calls and checks
she
on
lives
you,
in
okay?
Fairburn.
I hope she
Yes,
calls and checks
ma'am.
on you. They can call and check
Yes,
on you. I
ma'am.
hope that they
Okay,
do.
so
I
yes,
want them to
ma'am.
check on you with your
Yes.
son there. Please
Yes.
check on your grandmother or your mother.
She do periodically when she can. She come by and check on us anyway.
Okay,
But
good.
the thing is that he needs to be with me, and I don't want him to be taken away. He's coming home, Judge. Please send him home.
Yes, she gave a signature bond, which means he's going to get released.
Oh, okay. So
It may be beneficial if she wants to place her number in chat, and Mr. Morrell can give her a call and explain everything. I think, Your Honor, especially given the lack of history, they just may not understand the terms that we use.
So he's getting a bond to come home, but he's got to have no further violent contact with you. And if he
Okay.
does,
Okay.
and the police is called, he's going back to jail
Okay.
and the bond will be doubled. So
Okay.
I'm putting that in place, and I told you against my better judgment, but I'm going to hope that it all works out and that your daughter and granddaughter keep check on you.
One more
And, you know, they don't
thing.
have to come by, but they can call you.
Yes, okay. One more thing, Judge, if I may ask.
Quickly.
Whatnot. So my daughter think I talk too much anyway, so she's getting on me about talking. But I need my son and he needs me.
We're gonna get you off because you're not understanding what I'm saying. I'm going to allow that, but there are conditions to that. Okay? And the
just
conditions have to be followed. He has to be treated. He has to comply with that treatment. He has to take his medication. Been doing it long enough to know that a lot of them don't
Yes.
do it and they end up back
I'm
here.
so sorry,
We're gonna
Judge.
hope he doesn't.
If I may, I will just explain it to her once because I think she's not understanding what's happening here. And
Okay.
she's going to keep.
But that makes me more worried, to be real frank about it, that maybe he should not be there. Because, you know, I've said that the signature bond, but he's going to come home. He will make those appointments, but he has to comply with the treatment and do that. If not, then he's probably going to be back here. I don't want that for him, but sometimes unless you get him into some inpatient treatment and something significant, you know, it's a cycle, unfortunately.
I
And so
understand
I
that.
hope that it's not, because this is his first arrest. So I'm going to allow him to come back, but you've got to explain to him that he has to cooperate too. And if he doesn't, then it's not going to go well.
Yes.
Okay.
and
And
then
we
Ms.
want you to be
So
safe. I
it's
don't want you to be hurt. I don't want you to be in fear. And I don't want you flipping over no tables.
Right.
Okay. So let's hope he will comply with that and understand what he needs to do as well in order to stay out of jail. Okay. All right. Good
and
luck
Ms.
to you.
Gloria, take down my number. You ready? Because I don't want you to say your number on this live stream, but I don't mind my number being out. You ready? And
Okay.
Ms. Carter, you can take my number down as well.
Right.
It's 404 612 3678.
678. Okay.
And then if someone can call me, my phone is on Do Not Disturb right now, but call me and leave Miss Gloria's phone number and on my voicemail, and I'll call when I finish court today. But
Okay.
call right now because I got to stay on here to finish some other business.
Okay. Thank you. And we really
All right.
appreciate it, Judge. And
All
we'll
right.
make
You're
sure we get
welcome.
everything explained to my granny.
And
All
are
right.
we
Good luck to
able,
you all.
are we able to add at least 3 anger management classes to that? Because if he doesn't have any issues with competency or anything, he should be able to at least do that. Well,
Yes. We can take those free through pretrial.
yes.
Okay.
No opposition.
All right.
No, we're done, Miss Gloria. Call me.
All right. Thank you. All right. Who do we have next? Are we done? Let's see. Miss Lewis.
I
No,
think
I
he
am.
done.
We still have Mr. Parker, Davario Parker,
And
and
Marshall.
Mr. Shrine.
What are we doing? 13, Marshall.
That was, I believe, competency calendar. I know it's a reset, Your Honor. I thought it
Is
was
it?
already placed on competency calendar.
What do you have, Miss Lewis?
That is not correct.
Oh, okay. I
He's a reset.
apologize.
He's a reset from yesterday.
Oh,
I heard there were 7 resets on this
Yes,
calendar,
and he was one of them.
okay.
and this was one of them. So what are we
Yes,
doing?
ma'am.
Okay. I apologize. On Mr. Marshall, he was already reset from yesterday. He's going to need a
That's one of the
competency
7.
calendar. He is not allowing us to speak to him, Your Honor.
Oh, okay. Where are you going to put him, Miss Lewis?
Well, I'm gonna put him on the calendar, but I'm just saying, is there a bond already set in this?
And I need to set him a bond.
There's a $1,000 surety bond on both counts. That was
So
set by the magistrate.
So
he's not being
2,000
held.
surety. I'm inclined to just leave it at the 2,000 surety.
Well, it doesn't sound like he's waived his presence, so we probably need to wait I show on my notes that he refused to come to court yesterday, so.
And that
And
is
he's
the
still
same.
refusing.
He's still refusing.
So we don't have a waiver.
We do not have a waiver.
So I can't do anything.
Yeah, you could be reset him to Monday and then
Okay,
hopefully get a
reset him
waiver
to
by
Monday
then.
and we'll see what happens. Okay.
Okay.
Next one we have is,
And don't forget Monday is a holiday.
we still have court.
I know. I'm just letting y'all know.
Today was a fake holiday to
tomorrow. Today was a
not a fake one.
Technically, today was a holiday.
My husband is waiting on
And
me right now.
somebody's dressed and they're red and white, ready to go.
Go slap this makeup on and drop these children off, but carry on, y'all.
Okay.
We understand. We do understand. So
Position number
15, Parker. What are we doing with Parker?
Parker, we can go forward, Your Honor.
And have a waiver. Okay.
Yes, we have a waiver.
All right, 26 CR 0010088A. Pretrial, what do we have? Possession of drug and related objects.
33. Got an open case out of the cab. Possession of amphetamine, obstruction. Possession with intent. Got an open hit and run, suspended license. Shoplifting, false representation to police. On probation out of the cab. Criminal damage to property, entering auto. On probation out of the cab for burglary. Got FTAs two from 21, one from 24. He got a probation hold and wanted out of the cab county. What else?
Okay.
Possession of a firearm by convicted felon as well. Level 3. That's it.
All right. State.
Recommendation was $1,000 surety bond. Stay away from 369 McDonald Street, Atlanta, Georgia. No drugs, alcohol, or weapons while on bond.
All right.
And Your Honor, Mr. Parker's 34 years old. Your Honor, he is currently homeless, but he's lived here since he was 8. He does have 3 children, 8, 6, and 3. He has graduated from high school, has some college, and when he is able to do work and be employed, he does some residential repair work, Your Honor. Primarily, his family does live in Alabama, so of course we would just ask for the bond to be as low as possible.
All right, I'll do the 1,000 surety. Stay away from the incident location. No drugs, alcohol, weapons, or guns while on bond. And I guess that's it. So does he need a social worker visit just because of the homelessness, or see if they can provide any resources?
That's fine, Your Honor.
All right, that's it. And let's see, is that all of them?
No, Mr. Shrine, the bind over, Your Honor.
So I didn't realize it was there. Was I supposed to be doing that one, Miss?
I was going to say, who did you all send me an add-on? I think
we don't have that case, and it was not on the pull sheet.
Oh, okay. Well, I did have it, but okay.
What was the name?
I had it as a bind over, but okay.
He does have, he or she has a bond. I did just look up at it, but I would have to request the warrants.
Okay.
And I don't see it.
But it looks like he got a bond from College Park yesterday, $500 on the shoplifting and $250 on the disorderly.
Okay.
So we're going to just leave them where they are?
Yes, because I don't have an accusation number for them unless I have to do everything underneath the warrant number, but we don't have nothing.
Okay.
They stay having the keys.
We'll just leave it at the $750 at what he has now.
He can be reset to an SAP calendar.
If you could do that, that would make sure if he's still in jail, it would kind of keep our fingers on him.
Because I do believe he'll still be in jail. So if we can do that.
Okay, so I guess y'all accused him yet in the queue?
No, I just realized it was still there. So I'm gonna work on it as soon as we get done.
Okay, well, as soon as you accuse it, then we'll put him on the next available SAP calendar.
Okay.
You ready to go over the calendar?
Yes, ma'am.
I should get off my phone. I'm over here trying to see what time my date night is. Okay.
I was going to say somebody's making dinner reservations, I bet.
Everybody know that sorry about my raspy voice, but I'm catching a little cold here, changing sinuses. But everybody know the SAP court date reset is the 26th of February.
Yes.
Position number 1 is a total of a $3,500 surety. It's going to be reset to the competency counter at 11 o'clock on Thursday, the 26th of February. Position number 2 is a total of a $5,000 SOB through pretrial level 1, reset further notice. Position number 3 is a $1,000 surety, reset for SAP. Position number 4 is a
You
total
had
of
three at 4. Did you have 4 or 5?
I
3.
have 1.
Oh Lord, I mean, well, maybe my scribble handwriting, it is
Okay,
1.
number 2, let me go back over. Number 1, I have 1,000 on the disorderly conduct, 1,000 on the criminal trespass, and $1,500 surety on the simple battery. Came to a total of $3,500.
Yes.
That's correct.
Okay, and he's reset to the competency counter.
Right.
And then position number 2, I have a total of a $5,000 SOB through pretrial, $2,500 on each case. I mean, each charge.
Yes.
Okay, and that's reset further notice. Okay, position number 3 is a $1,000 surety, reset for SAP.
Yes.
Position number 4 is a total of a $5,000 SOB through pretrial level 1, reset further notice. Position number 5 is a $500 surety, reset for the jail competency counter for 226. Position number 6 is a total of a $1,000 surety, reset for a regular SAP 226. Position number 7 is a total of a $3,000 surety, reset for SAP on the 26th. Position number 8 is reset to the next SEA counter, which is Monday, February the 16th. Position number 9 is a total of a $10,000 surety, reset for SAP 226. Position number 10 is a total of a $9,000 SOB through pretrial level 2, reset further notice. Position number 11 is a $1,000 SOB through pretrial level 2, reset further notice. Position number 12 is a $2,000 SOB through pretrial level 1. That was a consent bond order, reset further notice. Position number 13 is going to be set to the SEA counter for Monday, February the 16th. Position 14 is a total of a $3,500 SOB through pretrial level 2. Reset for the notice. Position number 15 is a total of $1,000 surety, reset for SAP. Position number 16 is a $5,000 cash bond only, reset for SAP. Position number 17 is a $1,000 surety, reset for jail competency counter for February the 26th at 11 o'clock. Position number 18 is I got $28,000 surety, which he has already preset. That was on his regular bond, reset for SAP. Is that correct?
And that's
John?
28,000, not 2,800, right?
That's
Correct.
28,000, yes, not 2,800. That's why I want
That's
to.
what it
Yeah,
said.
that's what they got on the booking screen.
Mm.
28,000.
Mm-hmm.
I'll make sure that's correct. Okay, and that's reset to SAP 226. Position number 19 is a total of a $5,000 surety, reset for SAP. Position number 20 is a $500 SOB through the jail, but I'm also going to keep those two cases together so that that's also going to be reset to the 26 also. If he makes bond on both of them, then both of them will be reset further notice. But I'm going to put number 20 also with number 19.
Right.
Position 21 is a total of $1,000 surety, reset for SAP. Position number 22 is a $1,000 surety, reset for the jail competency counter for February the 26th at 11 o'clock. And position number 23 is a $1,000 surety, reset for the jail competency counter at 11 o'clock on February the 26th.
Wait, say that again one
Questions
more
or
time.
corrections? Huh?
Say Woodies one more time.
Woodies is a $1,000 surety, reset for the jail competency counter for February the 26th at 11 o'clock.
Gotcha. Thank you.
All the cases for the jail competency counter are reset for 2 weeks out. But
Got
you
it.
always can submit those eval orders way in advance before the counter, so we get that process started.
I understand.
Mm-hmm.
Okay, anybody got any questions or concerns or corrections?
No,
I'm getting right over to you, Judge.
thank you. They're
you,
like,
everybody.
don't string this out. We're ready to go. Right. All right. Enjoy the rest of your evening, everybody.
Same,
Absolutely.
everyone. Happy Valentine's Day.
Same to you. All right. Bye-bye.
Bye-bye.